So the Supreme Court's recent 8-1 decision in the Rahimi case is now being used to support Texas in their dispute with the Biden administration over the border. So let's break down what is now happening. Now, really quick before we jump in this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. They have amazing supplements. I love their protein shakes and all of that. But one of the things I really love about them and the people that work there is essentially that they're pro-freedom, they're pro-2A, and they support what we do here on the channel. Not many companies would step up to support this type of content on YouTube or just in general. And 1st Phorm's one of those companies that really believes in freedom and the Second Amendment. So if you want to get amazing supplements and you want to support a great company, check out 1st Phorm using the links down below. Now, as I mentioned in the intro in this video, we need to talk about a new decision which was issued by the Supreme Court, which is now being used to support Texas in their dispute over the border. The state of Texas is using a recent Second Amendment decision to support their right to self-defense. At the end of the Supreme Court's last term, you may be aware that they issued an 8-1 decision in a case called U.S. versus Rahimi. That decision focused on if a section of federal law which restricts the possession of firearms for people subject to domestic violence restraining orders is in fact a violation of the Second Amendment. We've talked about that decision a lot in the Second Amendment context, but now that Rahimi case is being used by the state of Texas in their lawsuit against the Biden administration for their border policy and the state of Texas putting in place the SB4 law, which essentially affirms that the state of Texas has the right to defend their own border. That decision is now being used by the state of Texas in their lawsuit to strike down the universal block that a lower court placed on their new SB4 law. Texas now argues that Rahimi shows that the facial challenge brought by the United States government against the state of Texas in SB4 is in fact invalid. But the federal government here argues that Rahimi should not change the outcome of the lower court at all. Rahimi does not apply, and the universal block on SB4 that they got from the lower court should in fact stay in place. Now, we need to do some background on this case so you understand what is going on with this specific lawsuit in Texas and how the Rahimi case is now being used. So Texas SB4 effectively makes it a crime for an individual to violate federal law by crossing into the state of Texas at any location other than a lawful point of entry. This bill was challenged by the Biden administration, and a district court on review issued a preliminary injunction preventing Texas from enforcing all aspects of SB4. So it was a universal block on SB4. The lower court found that SB4 was facially invalid. Texas then appealed that injunction up to the 5th Circuit Court of Appeals, and in response, the 5th Circuit issued an administrative stay on that lower court universal order. So essentially, they put a block on the block, and SB4 could still be enforced. So that was in favor of the state of Texas. And then what happened is various cases were consolidated. A bunch of cases were filed against SB4, and there were a ton of plaintiffs. All those cases were consolidated, and then those plaintiffs filed for emergency Supreme Court intervention. They asked for the Supreme Court to step in early and remove what the 5th Circuit did, essentially allowing SB4 to be blocked. Well, then we received an order from the Supreme Court which denied the Biden administration's request to vacate that administrative stay. And I believe that was a 5-4 order. Now, interestingly, in response to that Supreme Court order, that same day after the case was sent back down to the 5th Circuit, the 5th Circuit 3-judge panel that got the case in their hands then decided that they wanted to remove the stay on their own. So despite what the Supreme Court just said that same day, the 5th Circuit then removed it, essentially allowing SB4 to be blocked and the Biden administration to still engage in the conduct that they wanted. Then just a few days after that, the 5th Circuit heard oral arguments in this case. During those arguments, there were some concerns about if the United States government can seek this type of universal equitable relief against the state of Texas. There was also a lot of dispute during those hearings, especially from dissenting judges like Judge Oldham, who agreed with the state of Texas that the federal government here cannot file this type of lawsuit, and that the 5th Circuit to allow this type of action would be pretty much unprecedented. Judge Oldham and some of the other judges also seemed very concerned about the scope of relief that is proper in this case. They questioned whether or not the lower court there should have just issued that universal relief, blocking all of SB4. There was a lot of question about whether or not that was proper. Well, now the state of Texas has submitted the United States versus Rahimi case as authority to show that the facial challenge by the Biden administration and the universal block that they got on SB4 was in fact improper and should be reversed. The letter they submitted to the 5th Circuit states that counsel provides notice under Rule 28J of the Supreme Court's decision in United States versus Rahimi, which further demonstrates that the district court erred by facially enjoining SB4. In Rahimi, the court rejected a facial challenge to a statute prohibiting individuals subject to the domestic violence restraining orders from possessing firearms. The court explained that a facial challenge, the most difficult challenge to mount successfully, requires a defendant to establish that no set of circumstances exist under which the act would be valid. Said differently, to prevail, the government need only demonstrate that the challenged law is constitutional in some sort of its applications. The Supreme Court reversed a panel of this court because it did not correctly apply our precedents governing facial challenges. Rather than focusing on the circumstances in which the challenge statute was most likely to be constitutional, the panel focused on hypothetical scenarios where the provisions might raise constitutional concerns. This court thus erred by slaying a straw man. Instead, when legislation and the Constitution brushes up against each other, a court's task is to seek harmony, not to manufacture conflict. Indeed, federal courts assessing a facial challenge lack authority under Article 3 to decide whether a challenge statute is also lawfully applied, rather than whether it has any lawful scope. This court should not repeat the district court's error on appeal. Plaintiffs have failed to show that the federal law preempts SB4 at all, let alone in every application. So this is a very interesting development in the state of Texas lawsuit over the border. I didn't really expect that Rahimi would then be used, after that Second Amendment decision was issued by the Supreme Court. I didn't think that it would pop up in a Texas border dispute, but now you have it popping up to essentially say that the lower court got the analysis wrong, that this SB4 law in some of its application is in fact lawful, and therefore just universally striking it down was improper. Now, of course, in contrast, the federal government is arguing that the Rahimi decision should not change the outcome of this case at all. They argue that the district court found that there was no constitutional application when it came to SB4. They stated in their letter to the Fifth Circuit that Texas's June 25th Rule 28J letter references the Supreme Court's decision in Rahimi. That decision does not advance Texas's cause. In Rahimi, the Supreme Court applied settled law to evaluate a facial challenge to the constitutionality of a statute. As this court recognized at the stay stage, SB4 is facially invalid because there is no set of circumstances under which SB4 could be enforced consistent with federal law. The district court therefore did not err in enjoining enforcement of all of SB4. So now you have the state of Texas saying that SB4 should be enforced when you look in light of what Rahimi said. And then the other side, the federal government is saying, no, the district court got it right the first time. Rahimi does not change the analysis at all, and all of SB4 should be blocked. So this is very interesting. A lot of very interesting arguments going on right now about what impact Rahimi should have on this whole border dispute. Now, whether or not the three-judge panel in reviewing this case is going to agree with the state of Texas or the Biden administration is yet to be seen, but it's very interesting, again, that you have a Second Amendment case, Rahimi, and the whole facial challenge aspect coming out of the Fifth Circuit now impacting the Texas border dispute. So, of course, if things change, if anything else develops, I will let you guys know. Also, if you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. And if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.